wasn't performing as it ought to within a democracy. So there had been very radical propositions on how this could be dealt with. There are people who proposed, for instance, when the Commission of Experts was drafting the current constitution that we have, some of the proposals they got was that the whole judiciary would be wound up, so to speak, and new judges appointed. But then it was felt that this would be unduly punitive because not the whole of the judiciary was rotten or unworthy, as it were. So the compromise that was struck was that in the schedule to the transitional provisions of the Constitution, it was stated that the whole of the judiciary be vetted. And by vetting, a special board would be created, which came under the Vetting of Judges and Magistrates Act, which was passed last year. Now, it was meant to start, as it did, with the Court of Appeal judges and go downwards. And this is how it will be done. It said that all the people who were in the judiciary as of 27th of August, that is the day 2010, that is the day the Constitution was promulgated, would undergo this vetting. And the vetting would involve a set of criteria basically meant to determine whether they were qualified to continue sitting in the judiciary. So it would look at their competence, it would look at their integrity, it would look at their temperament, and all the array of skills and responsibilities and skills that a judge ought to possess, or anyone sitting in the judicial capacity ought to possess. And all the 9 of them. The Chief Justice, as you know, had to leave in February last year. So it examined them, and it has found that 4 judges and the vetting board, rather, upon examinations, received complaints and presentations against all the 9, rather regarding the 9, but it found no, not complaints against all the 9, rather it received representations and found on the basis of what was sent to it that 4 of the judges ought not to continue to serve. In other words, were unfit for various reasons. Reasons including temperament, including that they were unfair to litigants, or they did not exhibit throughout their career sufficient skill, as it were, to protect litigants before them. And that this means is that vetting law under which vetting was done, that is the Vetting of Judges and Magistrates Act, says that the moment that determination is made, which was required to be made in public, which is why they called that conference, press conference as it were, or that function, and read out this. What it meant was that if a finding that a judge is unfit to hold office is made by the vetting board, that judge would immediately cease to hold the office and would proceed on leave. They are entitled, however, those judges, to appeal, but the appeal will not be before a court. They can only appeal before the review board itself, the vetting board itself, and the grounds of appeal are also fairly narrow. The only grounds under which you can appeal will, for instance, that a new fact as a reason which was not made before, then that would have led probably to a different decision. Okay. Now, it then means that for these 4 judges, whereas they'll be entitled to appeal, they can do it. They can go ahead in that forum, in that manner. As for the other 5 who have been held to continue to serve, they continue to serve as judges. Now, what this means then is that when these 4 judges cease to sit, it has certain implications. That, you see, at the Court of Appeal, it's an appellate court. The tendency is for them, actually, they tend to sit in panels of at least 3. There are certain exceptions. There's an exception, for instance, in the case of what we call in law single judge applications. These are fairly interlocutory and nominal applications which can be determined by a single judge. Now, it means then that if, for instance, there were part-heard matters, these are matters which either have been heard but are not finished, or even matters that may have been finished and reserved for judgment, but before judgment has been delivered, the judges who are affected, unless they succeed on appeal, those decisions cannot be rendered, which then means that practically speaking, they will have to be reheard afresh. Those which had not been concluded, they will have to be heard afresh. In certain cases where judges are eventually found unfit and have to leave, even after their appeals, then means that the decisions which they were sitting on but which have not been rendered, or which had been allocated to them and they've had partly, will have to be heard afresh. Now, as a litigant, that will affect you in the sense that you may have to pay extra for legal services. The anxiety that comes to normal people in dealing with a court case will continue to exist. Imagine a court case that had been heard to conclusion now has to be heard afresh on appeal, at least in the case of the Court of Appeal judges. And naturally, it means if you had a lawyer, he probably will insist that you pay him for the second hearing, for the second set of hearing. So those are the things which will affect litigants. In addition to the operations of the courts themselves may be affected in the short term until this is concluded.